कोई आने वाला है?
कोई नहीं।
फिर मैं सेक्रेटरी और फरुख कुरैशी साहब को ऊपर बैठाते हैं।
जरूर जरूर आए, मोस्ट वेलकम। Okay, we're going to start. Please, can I have your attention? We're running late, and my sincere apologies to our guests from abroad who've been waiting very patiently for this session to begin. Since we're out of time, we're running late rather, what we're going to do is combine the next two sessions, which will basically explore international experience with effective mediation policies and court annex programs, and we'll try to extract lessons which are relevant to Pakistan. And we're delighted that we have a speaker from Turkey, Professor Dr. Nuray Eksi. She is a regular speaker at seminars, conferences, and panels held in Turkey and in various other countries too. She is the founder and also editor-in-chief of the Journal of International Trade and Arbitration Law, as well as Istanbul Journal of Sports Law, which have been in publication since 2012 and 2019, respectively. She was also one of the lecturers at the Hague Academy of International Law in the Netherlands, lecturing on private international law in July 2006. Professor Dr. Eksi is the author and co-author of several books on private international law, nationality law, foreigners law, conflict of laws, international procedural law, international commerce law, international arbitration law, enforcement and recognition of foreign court judgments, foreign capital investments, and European Union private law. So a very distinguished speaker, and we will listen to her later on. Joining her will be Mr. Constantine D. Gavrila. Could I ask that this screen be muted? I can hear an echo. Can you please mute this screen here? Mr. Gavrila is a full-time professional mediator. He is the Chief Executive Officer and founder of the ADR Center in Romania. He's also a senior fellow of the Weinstein International Foundation. We heard about that foundation yesterday. He has extensive experience since 2002 in supporting individuals, groups, companies, governments, and international organizations to resolve a wide variety of domestic and international disputes. Mr. Gavrila has trained more than 1,000 mediators and has provided consultancy services to beneficiaries and governments from more than 20 countries to design and develop mediation programs. Mr. Gavrila is also a co-founder and general manager of Craiova Mediation Center Romania, Advisory Council's member of the Lord Slin of Hadley European Law Foundation in London. He's the first president of the Romanian Mediation Centers Union. He's vice president of the first Mediation Council, and he has served as co-chair of the Independent Standard Commission convened by the International Mediation Institute, which was mentioned by Justice Ijaz Ishaq in the previous session. Later on, I hope Honorable Chief Justice retired, Mr. Anwarul Haq, will also join us. Justice Haq was sworn as the 47th Chief Justice of the Honorable Lahore High Court in October 2018. He was elevated to the bench in February 2010 after more than 30 years of practice in domestic courts. During his time as a practitioner, he was legal advisor to various organizations including WAPDA, PTCL, Post Office of Pakistan, and etc., including Habib Bank. He also worked at the Human Rights Commission of Pakistan as National Council Minister and founded the Insan Dost Tanzim. He carried out extensive training on sustainable development in Nepal in collaboration with South Asia Partnership and made significant contributions as an author in the Daily Dawn, Daily Nuray Waqt, and Akhbar-e-Jahan. I'm still getting the echo, Nudrat. Can you please have that fixed? We will also be joined later by Honorable Judge Rebecca Westerfield. Judge Westerfield has settled and arbitrated literally thousands of domestic cases and cross-border disputes in the United States and abroad. She's a full-time JAMS panelist, 1992. Since 1992, Judge Westfield is widely perceived as a tenacious mediator. She is included regularly on the National Mediators List, Chambers USA, and was noted as being at the cutting edge of the field by her peers. Her extensive experience includes complex, multi-party, multi-issue cases with underlying insurance coverage disputes. She is particularly adept at dealing with matters that involve cross-cultural dynamics and high emotional content, such as business dissolutions, catastrophic personal injury, litigation, and family estate disputes. Parties have included Fortune 500 companies and other publicly owned corporations, Silicon Valley entities, and multinational corporations. And we will be joined also by Colin Rule. Mr. Rule is CEO of Mediate.com. In 2011, Colin founded Modria.com, an online dispute resolution provider based in the Silicon Valley, which was acquired by Tyler Technologies in 2017. From 2017 to 2020, Colin Rule served as Vice President of Online Dispute Resolution at Tyler. From 2003 to 2011, he was Director of the Online Dispute Resolution for eBay and PayPal. He is also the author of Online Dispute Resolution for Business and co-author of the new Handshake, Online Dispute Resolution, and the Future of Consumer Protection. He also serves on the board of the Consensus Building Institute and the Peace Tech Lab at the United States Institute of Peace. So without much ado, let me turn to Professor Nuray Eksi for her presentation. Thank you.
Thank you, Mr. Chairman. First of all, I would like to say hello, everybody, and also say Selamun Aleyküm and Bismillahirrahmanirrahim. First of all, I would like to express my deep sadness for the recent flood disaster in Pakistan. I wish God's mercy on those who lost their lives in the flood disaster. Turkey and Pakistan, and I must underline that Turkey has changed its international name as Turkey. Therefore, I will make a reference to Turkey as a Turkey. Turkey and Pakistan have been two friendly countries in all times of the history. The friendly cooperation between two countries has also extended lawyers of two countries today. Before starting my presentation, I would like to state that I am always ready to contribute our Pakistani friends in fields of law. Now I will give a brief information about why Turkey is not among the countries considered as an arbitration or mediation paradise. Ferda, she is one of the speakers from Istanbul today, but she can't participate to this session. And then she was going to make an explanation regarding mediation, and I was going to make an explanation regarding arbitration. But if you have any question regarding the mediation, I will try to answer your questions as well. But what I am saying about the arbitration, these statements are valid also for the mediation in Turkey. It is generally accepted that commercial disputes are settled rapidly and in a manner satisfactory to the parties through arbitration or mediation. From this point of view, making legal regulations which are hospitable to the arbitration as well as mediation has become an obligation rather than something that can be ignored. Countries, including Turkey, that take notice of model laws prepared by international organizations as the basis for their respective domestic laws have started to revitalize or modernize their arbitration and mediation rules and laws in recent years. Turkey is also enacted certain rules regarding the arbitration and mediation since 2001. The intention of the states to attract legal disputes to arbitration and mediation centers located in their respective countries also plays an important role in making these legal regulations meet successfully the requirements of international standards. The preference to a place and arbitration in a country is to a very great extent determined by whether the country has already taken legal measures to reduce the interference by local courts in the arbitration process. In the past, in accordance with the Turkish arbitration legislation, the intervention of the courts in arbitration was quite comprehensive. However, with the subsequent legal regulations, the intervention of the courts in arbitration has been reduced to a minimum. Along with reducing the interference of the courts with arbitration, shortening the trial duration in arbitration, existence of specialized arbitrators relating to the subject, allowing the parties to freely choose the place and language of arbitration, reducing the formalities related to the arbitration procedure to a minimum, ensuring maximum confidence in arbitration, which is a real problem in Turkey. Arbitration-friendly attitude of the courts are the most significant matters considered by the actors involved in international trade. An arbitration jurisdiction which ensures these conditions will have the opportunity to be preferred by the actors involved in international trade. In addition, facilitating the enforcement of arbitral awards is important as well. In the past, the Turkish Court of Cassation interpreted a public order very broadly in the enforcement of foreign arbitral awards. The judgments of the Turkish Court of Cassation regarding the refusal of the enforcement of foreign arbitral awards due to the public order have created a bad reputation in the European countries. Although the Turkish Court of Cassation has for a long time narrowly interpreted the public order and has a liberal understanding in the enforcement of foreign arbitral awards, the effects of its past reputation continue. The main problem that Turkish courts have been faced in practice in terms of arbitration can be summarized under 6 titles. I said Turkish arbitration problems, but of course these problems also exist in international commercial arbitration. 1, impact of arbitration agreement on third parties. There is no common consensus about this issue, both in Turkish practice and academia. The second problem is arbitration realized in electronic environment. This is another problem. And also this is a new development in particular COVID-19 times. The third problem is validity of escalation clauses or multi-type dispute resolution clauses. Multi-type dispute resolution clauses compromise different steps which begin with various alternative dispute resolution techniques. In these clauses, arbitration is designed as the last step if the dispute cannot be resolved by preliminary alternative dispute resolution efforts. For example, the dispute settlement clause written in the contract by the parties has 3 steps. These steps are as follows. First step is the mutual negotiations of the parties. The second step is mediation, and the last step is arbitration. If the parties ignore the first 2 steps and file an action before the arbitral tribunal, then we confront with 3 main problems. What are these problems? What are these questions? The first question is, should arbitrators refuse to request to arbitration due to the fact that the parties have not exhausted the pre-arbitration steps? This is the first question. And the second question is, can the arbitral award be annulled if the arbitration was applied without pre-arbitration steps have exhausted? So this is the second question. And the last question is, can arbitral award given without exhausting the pre-arbitration stages be enforceable? So these questions are not determined in Turkish academia and also in Turkish practice, as well as international arbitration practice all over the world. So there are different applications in this problem. Another problem is validity of asymmetric arbitration clauses. What is asymmetric arbitration clause? Let me first identify this clause. The classic asymmetric arbitration clause is where only one party has the right to refer the dispute to arbitration, but the other must litigate. Whether those types of arbitration clauses are valid or not is not clarified either in Turkey or in other countries. Another problematic area is relating to the pathological arbitration clauses or defective arbitration clauses. For example, if the parties have a clause, arbitration clause in their contract, and they say that any dispute arising from this contract is subject to the EU arbitration center, then this is a pathological arbitration clause. This is only one example because there is no such a kind of arbitration center in any country. Then what we can do, how can we improve this arbitration, pathological arbitration clause, or we should say that simply this arbitration clause is not valid. This is another problem in the practice. Parallel proceedings, in particular in investment disputes, are another problem. Parallel proceedings means that the same dispute is taken before the court in different countries, or the same dispute is taken before the arbitral tribunal in different countries or in the same country, or the same dispute is taken before in a country before the court, in another country before the arbitration tribunal. This is another problem because there is a risk that conflicting decisions will be given by the different judicial process. What Turkey should do, adopting the policy of opening itself to the rest of the world and encouraging foreign investments to foster its economic development, Turkey has not remained isolated from the developments taking place in field of arbitration in the world, both in terms of domestic legislation and with international conventions to which Turkey is a party. In spite of the progress achieved in legal regulations and relative to international conventions, Turkey is not yet included among the countries that are considered as havens for arbitration. The most important reasons for this is the absence of well-known international arbitration center in Turkey. Besides, arbitration has not reached the desired level in terms of domestic commercial relationship either. Eliminating the lack of confidence and the reluctance towards arbitration, encouraging settlement of commercial disputes through arbitration or mediation, and challenges to increase the number of cases heard in the existing arbitration centers in Turkey are the matters that are required to be urgently included in the agenda, arbitration agenda for the future. I must tell that there are many arbitration and mediation centers in Turkey. In the last decades, in particular, the mediation centers are increasing and increasing. Let me tell some words about the mediation, as Mrs. Ferda is not among us. Commercial disputes in monetary nature and also monetary claims, certain employment disputes are subject to the mandatory mediation. That means that before filing a case, before filing a case in the court, you have to make an application to the mediation. There are many mediation offices in the courthouses. These are mandatory mediation offices created by the Ministry of Justice in the courthouses. If the parties file an action before a local court without resorting to mediation, then the court has to refuse to the case because, as I said, in certain disputes there is a mandatory mediation. The Ministry of Justice stated that mandatory mediation is successfully applied, and even the Ministry of Justice share regular statistics, and when we have a look at the statistic, you can see that Turkey has a successful career in the mandatory mediation. However, when we turn to the voluntary mediation, we can not say the same thing as we said about the mandatory mediation, because voluntary mediation, which is based on the